Okay, good evening and welcome everyone to the Orange County Clerk of Courts Legal Matters Forum Series. We appreciate you joining us tonight. Today's topic is the evictions process in this COVID-19 environment. I am Dane Weister and I'm the Communications Director for the Orange County Clerk of Courts. We do thank you for joining us, and we know that some other people will be joining us as we go along. And we just hope that you'll find this information we're providing you tonight by our panel to be very useful to you during these difficult times. Now let me introduce to you your Orange County Clerk of Courts, Tiffany Moore Russell.
Thank you, Dane, and hello everyone. Thank you so much for being here with us today. We know this is a timely and critical topic to discuss in today's environment. This webinar discussion will take an in-depth look at the evictions process and help provide you with information regarding your legal rights. As you all know, one of my strategies for this office is access to justice, and we have taken our legal forum platform from a brick and mortar type environment to more of a virtual setting in light of the changes in our circumstances in our community. But these forums are designed to give our citizens more access to the justice system and access to information they have the right to know. So I want to just acknowledge the folks that we have with us today. First, I want to thank my communications and community outreach staff for pulling this together. And I want to introduce to you the panelists today. So first, I want to acknowledge from my office, the Self-Help Center and Family Services Operations Manager, Ms. Roberta Walton. If you can wave for us. Hello, Roberta. We also have with us from the Legal Aid Society of the Orange County Bar Association, Attorney Jay Mobley. And from court administration, we have the Honorable Judge Dubois. And lastly, we have law enforcement representative Sergeant Mark Garcia and Corporal Kevin Brooks. So I want to thank you all so much again for taking time out of your evening to join us today for this legal forum. I'm going to give it back to Dane, who's going to go over some of our rules and operating, how to move forward as far as asking questions and to get this topic started. So again, you all have a great evening. We have a great information to share with you, and I'm thankful that you've chosen to join us tonight. Dane, I hand it back over to you.
Thank you, Madam Clerk. Okay, so here are a few housekeeping reminders. You will be able to submit any questions that you have through our Q&A section of the webinar you see here. So you'll be able to type those questions in, and we'll have a Q&A segment at the end of the webinar. We're going to try to do this verbally. So as we get the questions at the end, we'll be asking our panelists to try to provide some answers to your questions that you've submitted. Also, we want to remind you that at the end of the webinar, we'll have a survey that we ask you to fill out so we can get some feedback from you on what you thought of this presentation, and moving forward, topics that we might be able to continue to provide to you, the community. So this webinar also will be recorded because it will be posted on our social media sites and on our website later, so you can go back and watch it and you can share it. So there'll be an opportunity to go back and look at this information moving forward. So first on our panel, I want to introduce our very own Clerk of Court Self-Help Center and Family Services Manager, Roberta Walton. Roberta?
Okay. Good evening, everyone, and thank you so much for tuning in. As Clerk Russell and Dane shared, we have quite a treat for you in terms of just trying to prepare the community about bracing ourselves for what's coming forward. As many of you know, eviction filings have been on a moratorium here in the state of Florida and federally. But we are coming to a point where on August 1st, the moratorium for eviction and foreclosure filings is scheduled to be lifted. And as a result, we want to make sure that we are educating the general public about what's coming forward and from a procedural perspective, how best the Orange County Clerk of Courts office might be able to help. So I'm going to attempt to start the presentation. Hopefully I have this correct. Are we all set to go, everybody? All right, thank you, Dane. Okay. So Again, as I stated, both the federal government and the state of Florida have implemented a moratorium to protect tenants from experiencing additional hardship. As we know, times are really at an unprecedented state, and things are fluid. And so the government did step in to kind of break that barrier just a little bit, that fall, in terms of those people who might be facing an eviction as a result of the pandemic. What the federal government did, and the state of Florida followed suit, was they implemented some restrictions under the CARES Act that we've heard so much about. If you live in housing covered by the CARES Act, your landlord cannot file an eviction case against you for unpaid rent until the moratorium sunsets. As I stated, the moratorium is scheduled to sunset on August 1st, 2020 here in the state of Florida. And so if someone has tried to file an eviction against you prior to that time, the clerk of court has worked closely with the sheriff's office about not issuing any summons and not serving any summons for unpaid rent evictions. That does not mean all other evictions, just those for unpaid rent. Your landlord must give you written notice at least 30 days before filing an eviction case in court. We know that oftentimes the lease agreements are the ones that dictate those terms, but here the CARES Act has implemented some additional measures to help break, again, that hardship. Again, landlords that receive forbearances, and I think this is a very important one. If a lot of landlords who have mortgages on their property have reached out to the mortgage loan servicer and asked for forbearance to halt payments from paying their mortgage during this pandemic. If they've applied for one of those equal protections also apply to the renter who's renting that particular dwelling unit. And lastly, your landlord can still file an eviction, as I stated earlier, if the eviction is for any other legal reason pursuant to the Florida law. Here, I just wanted to break the terms out from the Federal CARES Act just a little bit. Here are the types of properties that are federally funded that also fall up under an eviction and foreclosure moratorium. If there are properties that receive funding or are funded through public housing, Section 8, or Fannie Mae, Freddie Mac mortgages associated with it, or any of the FHA federally funded loans, originally that program was supposed to sunset on July 24th and July 25th, that moratorium was supposed to break. Recently, the Secretary of Housing extended a new, extension, and that those properties have been extended through August 31st, so no evictions or foreclosures can take place on any federally funded properties where homeowners are participating in one of those type of mortgages. Now that program has been extended to August 31st. So that just gives us a little bit more time for those properties that are backed or participate in some type of federal funding. I also want to carry out, I know we're talking about, a lot of times when you think about mortgages, you think about single family homeowners. I want to make certain that we have a lot of apartment complexes across Orange County and the metropolitan area that also receive federally backed funding. And so that means those apartment complexes cannot evict those tenants through August 31st as well. Here, I just kind of wanted, as we continue to dive into the procedural part about eviction, to just lay out a very general definition about what eviction is. An eviction is when a landlord forces a tenant to move out. And in Florida, eviction actions are governed by Chapter 83, Section 2 of the Florida statute. So anything you'd like to know about residential eviction cases, which is primarily what I'm going to concentrate on, You can find through the Florida statute in Chapter 83, Section 2 part of it, because again, we're talking residential. Section 1 deals with non-residential. In Florida, a landlord cannot simply evict a tenant without a court order. A lot of times we have people who show up at the self-help center at the courthouse. They walk into one of the clerk's lobbies and say, you know, I'm facing an eviction. Someone posted a letter, or my landlord knocked on the door and told me I had to get out. Or they were calling the sheriff's office to come put me out. Without a court order, you cannot evict a tenant from a property. In order to obtain an order from the court, the landlord must first file a complaint for eviction with the clerk of court's office. And again, that complaint must be litigated through our Ninth Judicial Circuit Court. So to legally evict a tenant, a landlord must first send all of the required notices as listed in the Florida statute. There are several different type notices. I'm going to get to that in just a second, but those required notices must be sent, and they can be posted on the door. They can be mailed certified. They can be hand delivered, but you must have a copy, and the landlord needs to keep a copy and notate exactly when that notice was provided to the tenant. Thereafter, the landlord must file an eviction, a lawsuit, in other words, with the clerk of courts. Then they must, again, as I stated, obtain a court order signed by a judge entering a judgment for possession. Sometimes we go through an entire court case and the judge may not sign the judgment. You must have a signed order and an entering of a judgment of possession. And then that qualifies that landlord if that tenant does not voluntarily leave once a judgment is entered to obtain a writ of possession. The writ of possession is issued through, again, the clerk of courts, but then that ensues the assistance of the sheriff for the sheriff to serve that writ and give that person a 24-hour notice to vacate premises. Here is a loftier flow chart that kind of gives you from A to Z, from posting and hand delivering that notice, and going all the way through the judicial process of filing an eviction through the clerk's office, having that eviction case litigated through our court system, and then getting the sheriff to participate with serving the necessary documents for judicial process, i.e. the summons to have the person served, and then later on a writ of possession. This really is a reference chart, and this chart will be can be found and located inside the Self-Help Center at the Orange County Courthouse in room 340. Here, I wanted to identify the required forms for filing a residential eviction. These forms have been approved by the Florida Supreme Court and are offered to the general public for free through the Florida Bar's website. We also have these forms packaged, because certainly the forms are not packaged on the Florida Bar's website, but we offer these as the eviction packet for sale for a small fee at the Orange County Clerk Self-Help Center and at the Civil Division in room 350, again, at the Orange County Courthouse. But here it identifies, first you start with the statute again, and then you fluctuate to the elements. Again, what's very, very important when you want to file an eviction case, or if someone files an eviction case against you, is to make sure there is a legal landlord-tenant relationship. That must exist. And that will be spelled out again in that statute. If you're interested, please go and look that up if you are facing something like this. Again, the other part is there must be a violation of some sort, even it may be a lease violation or and/or an unpayment of rent. Again, up until August 1st, no evictions can be filed. But once that ban is lifted, if you have not paid your rent, yes, a landlord can evict you from the property that you currently reside in. Here, you must have a civil cover sheet. That second form I wanted to explain, it's called the Owner's Authorization for Property Manager. A lot of times we have property managers who act as agents for the property owner. If that is the case, that person can still start an eviction filing, an eviction case with our office, but they must have this form signed and attested to by the owner with the filing. Then you have a complaint for an eviction. There are a few different types of complaints, one for damages and one simply for possession. A copy of the notice, again, that notice we talked about that's required, that you must do before you can even start an eviction filing, and a copy of the lease. Keep in mind, here in the state of Florida, oral leases and written leases are both legal. Okay, so if there is a written lease, you must bring a copy of that lease. Then a summons will issue. These are issued by the clerk of court when you come in with these other forms ready to file. In terms of, if I'm speaking to a landlord, there's a 5-day summons, which according to the Florida statute, evictions qualify as summary proceedings. So that's really quick. You have 5 days from the time you are served with a copy of the complaint for possession, to respond to the court. Again, that's a $40 fee to have this summons served by the sheriff's office. And it's a $10 fee that we at the clerk of court assess to issue the summons. If you are simply, and again, that 5-day summons and complaint for eviction is simply, I just want them out. I want you to leave, right? And we see that all the time. But if you are saying, I not only want you to get out, but I also want my unpaid rent. And I want you owe me, you destroyed my home. And I have, I've gone in, I've done an inspection, and you owe me some damages. So that's a 5-day summons and a 20-day summons. So again, we're talking two counts here. You want them gone, count 1, 5-day summons, and you want the unpaid rent that is due. And that's a 20-day summons. So they're $40 each. And on the summons, a summons should be, let's say it's a husband and wife staying there, and you want them both gone. You can't put them both on the summons. You need to have both of them served because they both signed the lease agreement. It is based upon whose name is on the lease agreement. You want everybody served if they're listed as a tenant on the lease agreement. But again, the 20-day, you have 20 days to respond to the damages summons, and 5 days again, because it's a summary proceeding for possession only, to respond to the possession only. A certificate of mailing. This is something that we ask that you complete because we want to certify that the tenant has received a copy of the complaint if constructive service exists. Constructive service is the sheriff's office goes, knocks on the door, attempts to serve the complaint, can't get anybody to open the door. The sheriff, when it comes to possession only, can just post a copy of that complaint on the door, and then they will let the clerk's office know, and the clerk's office would then mail a copy along with a certificate of mailing attesting that a copy has been mailed to the address that we have on file. The non-military affidavit. The state of Florida will not let you evict someone if that person is deployed in active duty military. So we need you to also, as a landlord and someone who's filing an eviction case, to attest that the tenants, to the best of your knowledge, are not active duty military. And then the other ones, when I say judgment, this is if you do not respond timely, then the landlord, from a tenant's perspective, the landlord has a right to ask the clerk first. It's a 2-part process, to motion the clerk for a clerk default, and then to motion the court for a final judgment of default. If you're going to do that, you need to include an affidavit of damages with that, and then the courts will enter a final judgment because you, the landlord, are entitled if a timely response was not made to that judgment. In most cases, nothing's final. And then a writ will execute, and you can take that to the sheriff's office and have it served upon the party. Here, I talked previously about those required notices. I just wanted to take a few minutes to just break those down, because usually they come in the form of a 3-day notice. That 3-day notice is for that summary proceeding of unpaid rent for possession only. And so if it's an unpaid rent action, then you can do a 3-day notice. If it's a violation of the lease agreement action, it's a 7-day notice. If we're dealing with an oral lease agreement, or we're dealing with a holdover tenant, meaning the lease expired on June 30th and you're still there because you can't leave right now, and the landlord is acknowledging you as a holdover tenant at any given point when they want you to leave. Usually it's a 15-day notice, but it really does depend on how frequent you pay your rent to that landlord, because it could be as minimal as 7 days if you pay on a weekly basis. But if it's month to month, which is a 31-day period, usually what's required is a 15-day notice for you to leave. Here is just a breakdown of the court procedures when it comes to the eviction, and I won't tarry because we do have a judicial expert coming right behind me. But again, you have the 3-day notice, and from the 3-day notice, and we're talking unpaid rent here, eviction filing, a summons that will issue and needs to be served by the sheriff's office, and then you have 5 days to respond in writing to the official lawsuit for eviction that is being filed against you. It is so important for you to provide a timely response, because again, without a timely response, you're going to entitle that landlord to file a motion for default against you, and that's going to entitle them to, in like I said, in most cases, to a default judgment from the courts. And then last, of course, I talked about that court default and the final judgment for writ of possession. And that means if you're not going to leave voluntarily, if a legal eviction is filed against you, then typically that writ of possession will be issued by the clerk's office, and the sheriff's office will come in and serve that writ of possession. I don't think I said it earlier, but that writ of possession, the fee is $90 for the clerk, for the sheriff's office, excuse me, to serve that. It's $40 for a summons and $90 for a writ of possession. Again, this is talking about the answer. The answer is that written response that we just talked about, and you have 5 days to respond with a written response. And when you're talking about a damages claim and the count towards that, you have 20 days to respond in writing. Just for a second, I'd like to say, from the Self-Help Center's perspective, we have a lot of people who come to the Self-Help Center because they intend to represent themselves in court. And oftentimes they come in with a piece of paper, a notebook paper, piece of notebook paper that they've taken out of their son or daughter's notebook, and said, I'm going to write the judge a letter because the judge needs to know everything that happened. And I always say, no, this is a moment of empowerment. I don't want you to simply write the judge a letter. I want you to make sure that you are representing yourself and preparing yourself accordingly to do that in court in front of a judge. So you need to file a written answer. We do have these forms available for you at the Clerk of Courts in the Self-Help Center and in the Civil Division, which is in room 350. Don't simply write the judge a letter. Respond to the complaint. You're not writing the judge a letter. You're responding to the complaint that has been filed against you. And so you need to read each paragraph, each allegation, and decide whether or not you agree with it or you don't agree with it. You admit or you deny. And for all other things, you say, I don't have enough information to do either. But you need to respond accordingly. And if you're going to file, if you do have evidence to say, you know what, my landlord, I don't understand why they filed. I paid my rent. I did what I was supposed to do. You need to be able to prove up those allegations. Again, the law is very, very clear, and I do know that the judge is probably going to touch on this, but even if you file a written response saying, I don't agree with this, you need to look at the amount that they are saying you owe, and be prepared to place that amount in the court registry. If you don't agree with that amount, you have the right to file a motion to determine rent, because you are disagreeing with the amount that is showed that you owe in the complaint. Keep in mind, if you say I owe $500 and your landlord says, no, you owe $1,000, you still on the hook for putting that additional $500 that you say you owe in the court registry, along with filing that motion to determine rent. Otherwise, you may not receive your day in court. And so I just think that's very important to denote. And again, we talk again about the court default in the final judgment. Here are the filing fees that you need to come prepared to the clerk's office with your forms. The filing fee is $185 to file for an eviction complaint. Again, it's $10 for the clerk of court to issue a summons. It's $90. That fee is paid directly to the sheriff's office for a writ of possession. And I don't think I put here $40 for the summons, paid directly to the Orange County Sheriff. And then the court registry fee. The court registry fee, in order for you to deposit the rent that you owe, or that you think you owe, into the court registry, there is a small fee. It's 3% of the first $500 and 1.5% of the remaining balance. And that is also paid. The clerk of court does maintain the court registry. Just a couple of key tidbits that I have denoted down here. If you go through and I'm speaking from a tenant's perspective, a full hearing for an eviction complaint, and it comes out that you are the prevailing party, you just continue on. Prepare to pay your rent according to your lease agreement on the following month. And you can stay there through, or unless you get another notice, but you can stay there through the terms of your lease agreement. Keep in mind, if you hire an attorney to represent you, and or if your landlord does, the prevailing party is entitled to attorney's fees and costs. And they must ask the court for those attorney's fees and costs. They're not automatic. You must ask for them. Just really quick, I talked about, and we see a lot of people come in because they've not read the statute. They don't understand what's the correct way to evict someone or not. And they will come in and say, hey, my landlord's not keeping the place repairable. It's not tenable. What should I do? And, we're there to accept eviction case filings to start a new case action for the court. What you should do, there's tons of collateral and information out there. I always tell people, reach out, call legal aid, call legal services, go online, reach out to an attorney. But there are certain things that are prohibited in terms of from a landlord. Landlord can't just treat you any kind of way and tell you to get out. You have certain rights. And again, I start with Florida Statute Chapter 83. Please go and take a look, and you will see some of these examples of what is the correct reason a person can evict you and when they can't. Here, when it comes to security deposits, if you are at the end of your lease agreement and or you have decided that you are going to leave at the end of this month before the ban lifts, you still, there are certain actions that a landlord must take in order to retain your security deposit. So again, I ask that you review these materials, look over them, and also go back and review Chapter 83 and look at the reasons why a landlord can claim. They must notice you if they intend to claim a portion of your security deposit, and they have a limited amount of time to do so. Otherwise, they waive that right and they have to return the full amount. The other thing is, Don't wait until the landlord files an eviction case against you to then say, but you know what? I've been living and there's mold in the house and he didn't fix this and he didn't fix that. And he's not been keeping up with the house. If for whatever reason you feel like the landlord is not keeping up with their responsibilities and neglecting their duties, their statutory duties as a landlord, you do have a right to withhold rent, but there's certain steps you must go through before you do that. You can't just say, I'm not paying him or her because they refuse to fix the house or the place that I'm renting. You have to notify the landlord and give them 7 days to cure whatever it is. You have to give them 7 days to repair it. And then if they don't, then you can withhold the rent. But even if you withhold the rent, keep in mind, you can't spend the rent. You have to hold on to it in an account for them if you want to go that route. Last thing, what if you can't pay your rent? The first thing I recommend is you notify the landlord to ask if they, especially in the times like this, ask them if they would give you an additional extension. And if they're willing to do that, negotiate what that looks like and make sure you do that in writing. Don't just get an oral something over the phone. Get something in writing that's concrete that you can defend and or justify. Another thing is there's a program that the Orange County Family Services Division has in place, and it's called EPIC, an eviction prevention program. And this program has some criteria because it's for families. If you're still working and getting a paycheck and there's kids in the home, you may qualify for the EPIC program. And we do have those referral forms at the Orange County Clerk Self-Help Center in room 340 at our courthouse. Lastly, there are other crisis assistance agencies out there. I recommend you call 211 and receive a referral about how to get some assistance. Here again is what the referral forms look like, for the Orange County EPIC program. It's a wonderful program that Mayor Dimmons and his staff has put in place. Again, that criteria is you must have already been served a 5-day summons and complaint. You must have kids who reside in the home where you're being evicted from, and you must still be working. You cannot have been laid off. So these are working people who still experiencing crises that the EPIC program is trying to help prevent you from being homeless. Lastly, I just want to share with you, this is Clerk Russell's greatest kept secret. It is, or not greatest, best kept secret. It is the Orange County Self-Help Center, where I have the privilege of managing a great team there. I have 5 full-service deputy clerks. We have a partnership with the Orange County Bar Association where we have virtual attorney consultations that are being held, that a person can schedule a virtual attorney appointment online by going to www.myorangeclerk.com. The appointments are $1 a minute. They are conducted via the Zoom application, so you still get that visibility. You get that one-on-one assistance with a licensed attorney who is a member of the Orange County Bar Association. A wonderful program. No, the attorneys will not represent you, but what we do is we stand in the gap. If you intend to represent yourself, we are here to empower you to do just that by answering questions about court process and court procedure and about how to represent yourself in court. And not only do we handle eviction cases, but we handle all family cases and small claims. Again, we are in room 340 of the Orange County Courthouse that is on the 3rd floor, and we are open Monday through Friday from 7:30 a.m. to 4 o'clock p.m. So thank you so much for having me, and I will turn it back over to you, Dane.
Great. Thank you, Roberta Walton, who is our Clerk of Court Self-Help Center and Family Services Manager. Great information, and it's a lot. It's a lot to digest, but we're going to move right on along with the next panelist that we have with our forum here. One quick thing I want to say is if you do have a question, submit it, write it into the Q&A section. I saw that we had maybe one or two people raise their hand, but if you have a question, we're going to take them at the end. So write in your question into the Q&A box, please. So up next now, we have Attorney Jay Mobley, who is with the Legal Aid Society of the Orange County Bar Association. Thank you, Jay, for joining us.
Thank you for having me, and thank you for hosting this informational forum. As he said, I'm Jay Mobley with the Legal Aid Society of the Orange County Bar Association. I am the Senior Housing and Consumer Attorney. For those of you who don't know what Legal Aid is, we're a private nonprofit organization. We do not charge for our legal fees. We do not charge clients for our help. We serve Orange County residents at or below 200% of the federal poverty level in a variety of areas, one of which happens to be housing. We are working remotely. Our main office is closed right now, so please don't go to our front door. It'll be locked. You'll need to call us. We're working remotely, but we're at 100% operational capacity. That number is 407-841-8310, and press 0 for our operator. You'll get a live person on the phone, and we can conduct intake all the way through consults and representation over the phone. So please don't hesitate to reach out. If you're another agency, feel free to refer people to us as well. So a little about what we do in the intake process. If you call us and you're faced with a problem with your landlord, you're behind in rent, you just want to know what your rights are. You maybe have been served a 3-day or 7-day notice or a non-renewal or something like that, and you just don't know what to do. Call us. We can review things for you. We can take a look at your lease or whatever notices you've gotten, and we can give you, an attorney's point of view on what your rights are as a tenant and what maybe your next steps should be. So please reach out to us. We have been working with other organizations, obviously the Orange County Bar Association, Young Lawyers Society, and other pro bonos around to expand our capacity to provide these consults. So come when the moratorium lifts, whether that's August 1st or if, maybe there's another extension, as soon as things start rolling, we will have the capacity to help folks. So please reach out to us. Normally on these kind of calls, I cover the eviction process, but Roberta did such a good job. I don't think I have anything to add on that. Basically, what happens if you call us, we're going to do an in-depth review. We're going to ask you about your situation. We provide a variety of service, from just a basic consult and advice if you're worried about your rights, or if you're faced with an eviction action, we do offer attorney representation in court. One of the things that I would say, a couple tips: don't avoid your landlord. I know it's stressful, but you need to deal with them. You need to talk to them. At the very least, you're going to know what they're thinking and maybe what their plans are. So that makes you a better prepared tenant. This is going to be a stressful situation on landlords and tenants. We recognize that, but you do have rights as a tenant, and we want you to be aware of those rights. So reach out to us. If you see notices on your door, or if you receive mail from your landlord, open it. Again, it's the awareness of what's going on, because we don't want it to be a situation where, you've been served by it posted on the door and you've ignored it. And then all of a sudden you've got 24 hours to move out of the property. We want to avoid that as much as possible. So feel free to reach out to us. And I'll be happy to take probably a bunch of questions when we get to the Q&A session. So that's it for me.
Okay, thank you. Again, Attorney Jay Mobley there with Legal Aid Society. So that's helpful, because we can just push on through, and then we'll get to more questions or get to that Q&A section of our webinar towards the end. Again, if I just want to share with people, any participants that are just joining us, that you have joined the Legal Matters Forum series presented by the Orange County Clerk of Courts. And we have a great panel here. This is the evictions process in this COVID-19 environment, which has definitely been a difficult time for all of us navigating through this time. So as a reminder, submit your questions through the Q&A portion in the box on the screen. And at the end, we will try to get to your questions and give you answers to them from our panel. So up next, we have the Honorable Judge Dubois, who's taking time to share with us a perspective from the bench. So thank you for joining us, Judge.
Thank you, Dane, and thank you, Clerk, and everyone else for being here tonight. I want to first welcome everyone and let you know that the courts have not closed. The courts have been open throughout this pandemic. We are restricted by certain Supreme Court orders and certain local orders with regards to the community's levels of COVID and where we are with regards to that. But the courts have not closed. All the judges are working hard, and we look forward to having everyone back in the building, hopefully here in the very near future. I'm going to try and share my screen so we can talk about some things. Let me see if this works. Did that work or no? You guys seeing my PowerPoint or no?
Yeah, we have it. We have it.
Okay. So, as been previously said, the governor issued an executive order statewide that halted all monetary evictions that expires August 1st at 12:01 a.m. That's on a statewide level. Locally here, as an administrative order, the chief judge of our circuit, Judge Don Myers, issued an administrative order that's 2020-11-04 that stops all foreclosures and evictions. However, it's only for the non-payment of rent. So as has been stressed before and talked about, Ms. Walton talked about it, Mr. Mobley talked about it, if you're a landlord and you have a tenant who's engaging in criminal behavior or criminal activity or is destroying your property, you can continue to file an eviction. You can continue to move forward on that and try and ask the court for some help in trying to get them out. I can't give legal advice. However, I would caution you that there are certain things, and Ms. Walton talked about self-help. You cannot go kick them out on your own. You cannot remove the stuff from the property and put it on the curb and do a curb alert on Facebook telling people, hey, there's free stuff on the corner of, Church and Central, and change the locks on your tenant. If the court finds out that happened, there could be repercussions and ramifications against you, the landlord, in favor in the benefit of the tenant. So as Mr. Mobley talked about, the current order expires August 1st at 12:01 a.m., which I believe is a Saturday morning. So the courts are closed Saturday and Sunday, so you're not going to be able to come file your eviction. And for counting purposes and days purposes, when you're serving someone with a 5-day eviction, the courts don't consider days that the courts are closed, holidays, or weekends. So the earliest you're going to be able to file something and come to the courthouse would be Monday morning, August 3rd. And we are prepared and look forward to seeing everyone. Part of the complications that we're going to have, frankly, when we come back from this, when evictions are all filed and the 5 days has elapsed and there's a response, is all of our in-person hearings in Orange and Osceola counties, specifically Orange County in the Ninth Circuit, are suspended except for what the Supreme Court has deemed essential hearings. Essential hearings in the eyes of the Supreme Court are initial appearances if you're arrested, your arraignment for criminal charges, bond motions. There's nothing that domestic violence hearings, protection hearings, injunctions. There's nothing in the civil arena that has been deemed an essential hearing right now. That could all change if Chief Justice Kennedy wants it to change. And my guess is that we're going to have to work within similar confines to the forum we're having this community outreach in tonight through Zoom or Microsoft Teams to allow our county civil judges to participate and hear from litigants who want to have their case heard. So right now we're in phase one here in Orange County. We were in phase 2. The Florida Supreme Court has set up certain protocols that have to be met before we can move to certain phases for the safety and protection of all of the public that comes in and out of the building, but also for the safety and protection of court administration, our amazing clerks, and the judiciary and court administration personnel. So in order for us to move to phase 2, when we can have some limited in-person hearings, our COVID numbers in the community have to remain the same or decrease for 14 consecutive days. All of the evictions that we're talking about tonight are handled by our county civil judges in our counties in Orange County. We have 5 civil judges in Orange County. Judge Elizabeth Stars, Division 70, Evelyn Jewett, Division 71, Tina Caraballo, Division 72. Is it not sharing? Brian,
Judge, sorry to interrupt. We
Okay.
took control so we could advance the
Okay.
slides for you.
I appreciate it. Judge Brian Duckworth, who is in Division 73, and Judge Gisela Laurent, who's in Division 74. For landlords and tenants, when a landlord files a case, your case is assigned a number from the clerk of the court. It'll be 2020-CC-something-O. And then under that, it'll say division and have a number. And that's how you know which judge your case is assigned to. For a tenant, when you get your summons or you've been notified of your eviction, it'll have that same information. And that's who you should address your motions and your correspondence to. And that's how you would know which JA to reach out to, if we could go to the next slide, and how to set a hearing. So as I said, we can't have ex parte or direct communication with litigants, whether you're a landlord or you're a tenant. We can't have any communication or contact that directly relates to your case whatsoever. So we have our judicial assistants who are also working either remotely or in the building that will respond to emails and phone calls. And we just ask that you give them 24 hours to get back to you. I will caution you that they are not allowed by law to give legal advice. And the best thing they're going to tell you is to go make an appointment with Ms. Walton in our self-help center and speak to an attorney, or to call legal aid and talk to Mr. Mobley or someone on his staff. The judge nor the JA can give legal assistance, and please don't get frustrated with them if you call and they can't. If we can go to the next slide. Here are the email addresses for each of our 5 county judges in county civil here in Orange County. This is the absolute best way to communicate, to request a hearing, and to send copies of your filings that you file either through the self-help center or when you walk into the clerk of the court. Our clerks are amazing, and they try and get us every piece of paper that you file with regards to an eviction. But sometimes certain things just fall through the cracks, or there's a backup or a delay. And if we can't get to it, if we don't see it, we can't respond to it. So these email addresses are the best way to email directly to the judicial assistant. As Ms. Walton said, don't write us a love letter. Don't write us a sympathy letter. We're humans, we're compassionate, we understand, but we've got to follow the law. And you've got to respond to whatever legal pleading was filed. If you can go to the next slide. So Ms. Wallen talked about the process and the steps. Here's what we look for also. We need you, we did some analysis, and we average about 800 to 1,000 eviction filings a month when everything is normal. Unfortunately, with COVID and the amount of unemployment and uncertainty that we've had in our community, we expect those numbers to be a lot higher. So we're asking for patience, and we're asking for help from the landlord side as well when you file an eviction. When you come and you drop off your paperwork for a final judgment eviction, we ask that you provide 2 self-addressed stamped envelopes. Make it the address, one to you and one to the tenant. Put stamps on it. It speeds up things for us and makes us able to expedite your case that much quicker. We need 3 copies of a final judgment, 1 for the clerk to record, 1 for our judicial assistants to mail to the landlord, and 1 for our judicial assistants to mail to the tenants. 3 copies of the proposed writ of possession. That we can forward to the clerk's office so they will have it and be ready to go if you need a writ of possession. Part of the issue that we're going to have when we come back from this is what was talked about is there's language in the CARES Act that if it's a federally insured or federally backed mortgage, they can't evict or foreclose on that property. So there either needs to be something in the complaint that's verified that says this property is not backed by a federally backed mortgage, or an affidavit that accompanies your lawsuit, so long as the CARES Act is in place, something that tells the judge it's not a federally insured mortgage, because we have no way of verifying that or checking. We're taking you at your word. And we're not going to act on a case that we don't know. Next slide. So we have put in place some provisions and are prepared for the filing of the final judgments and the large numbers that we're going to see. We'll have drop boxes in the front of the courthouse at what we have a triage desk where you'll be greeted when you come to the courthouse by someone from the clerk staff and or someone from court administration to find out why you're in the building and to help expedite to try and handle things at the front door versus have people roaming around in the building and getting lost. Evictions will be handled in the manner in which they're received, first in, first out. We do have a mediation program that will be also doing mediations online via Zoom or Microsoft Teams. If you're a landlord and you wish to participate in the mediation program, or you're a tenant and you wish to participate in the mediation program, we also offer an online dispute program that might be able to help you. However, as Ms. Walton said and Mr. Mobley said, this is a pay-to-play state. The Florida statutes and the Florida law require that a tenant put the money in the court registry prior to the court being able to grant them a day in court, grant them a hearing. Very often when I was in county civil, I would get letters and things from people and they would put, a month's rent in the registry, but they owed 4. And as much as it pained me, I couldn't grant them a hearing because under Florida law, it has to be 100% of the money that is alleged to be owed. I've been talking to some of the landlords and trying to come up with creative solutions to avoid this onslaught and also work around some of these administrative orders and executive orders that we have to move some cases. And what I've heard from landlords, especially the big apartment complexes, they want to work with their tenants who are behind. They just need a means and a mechanism to do that. And so if you're behind, my suggestion to you would be reach out to your landlord. Tell them what you can do. If you can come up with a binding agreement that, hey, I'll give you half the money I owe you or 3/4 of the money I owe you and $100 a month or $200 a month plus my mortgage moving forward, they might be willing to work with you. I mean, I know when I was down in county civil, they'd rather have someone that they know in their property paying something rather than an empty unit or someone who they don't know paying nothing. So if we can go to the next slide. If there is a next slide. Oh, that's it. So I will answer to the best of my ability any questions that you have. Unfortunately, as a judge, we're not allowed to give legal advice and we have to speak in very vague and open-ended terms, and I can't really answer the hypotheticals, but I'm here. I'm happy to answer whatever I can when we get there. And I thank Clerk Moore Russell and Dane. I thank you, and Ms. Walton. I thank you all for allowing me to come and share the insight from the judiciary.
Thank you, Judge. The honor is all ours. We do appreciate you taking time out of your busy schedule. It's great information. So especially just some insight there from the bench. So the Honorable Judge Dubois, thank you for sharing your insight. Now they've been waiting, and last but not least, we have representatives from law enforcement. So we're going to turn it over to them. Sergeant Mark Garcia and Corporal Kevin Brooks, who are with the Orange County Sheriff's Office, and they have more information on that serving process.
Good evening. I'd like to first thank you for extending the invite for this important discussion. The Sheriff's Office, for the benefit of all those participating in this discussion, is essentially the documentation and enforcement mechanism for the civil courts. All day long, our phone in my office ring off the hook with individuals, landlords, and tenants seeking legal advice. The Sheriff's Office and its employees cannot provide legal advice. We refer people to legal aid and the self-help center routinely. Those are great resources. If a tenant is served a complaint or served a summons, the clock is ticking. Too often, when a deputy arrives to execute a writ of possession, residents are giving a legal argument to the deputy of why the eviction should not go forward. At that point, it's too late. Don't wait for a deputy to show up, and the deputy has no choice. Despite common perceptions that the Sheriff's Office is not taking sides of a landlord or a tenant, our actions are strictly ministerial. We are enforcing a court order by the letter. Whether we like it or not, it is the law. So if you do receive some sort of form, some sort of court notice, the clock is ticking. Proceed to either seek legal advice from an attorney or proceed to the courthouse and access the self-help center or go to legal aid. The deputies are not without, as the judge stated, we are human, they're not without compassion. We try to, as much as we can, take into everyone's circumstances. What we do on our end is to ensure that everyone is afforded due process. There's no skip steps. Everyone is taken first come, first serve. All cases are handled that way. All legal arguments need to be made prior to the issuance of the writ of possession. Once, like I said, all these proceedings are civil cases, and so the sheriff really has no input either way in the handling of these cases, the processing of the cases, what cases come first, what judgments are made. And lastly, just for the tenants that are participating in this and some of the landlords, there were writ of possessions, evictions that were issued prior to the moratorium, just prior to the moratorium, and there were 24-hour notices posted. For those that did receive 24-hour notices posted on their door, those will be reposted. There will be a notice given, so people do have the ability to make any legal claims, arguments in court. So we will not be immediately enforcing those 24-hour notices that were posted on the day of the moratorium. And I believe that's probably until we receive some questions. I think that's more or less what we have to offer at this point. But again, thank you for the invite for the Sheriff's Office to take part in this discussion.
Great, thank you. And I think we have Corporal Kevin Brooks, who was going to share some information as well. Corporal, do you have something you'd like to state?
Oh, Sergeant Garcia pretty much covered everything. So I do not at this time. I'll just wait for the questions also.
Okay, great. Thank you, guys. So there you have it. That is basically our presentation from the entire panel, but of course we're not done because we're going to be moving towards our question and answer session. For this portion of the webinar, we'll be answering some of the questions you have sent in. If you have any other questions, you may submit them at this time in the Q&A box. Type those in there. As a reminder, you may ask a question using that feature on the screen. Let's look at, we've pulled up some of the questions here. We even had a couple sent in. We actually had a lot sent in even before the webinar. So hopefully we can address those as well. We have at least one question here that we received before the webinar. So the first question that we have here is, if a landlord served a 3-day notice for non-payment and filed an eviction for non-payment during the federal and Florida moratorium protection, what remedies does the tenant have? Who on the panel would like to try to help answer that for us? I think this might be something for maybe Attorney Jay Mobley.
Sure, I'll take a stab at it. So if there was an eviction filed during the moratorium for non-payment of rent, and the person was faced with COVID-related, wage loss or something like that, I think the tenant can file a motion to dismiss based on the moratorium. That would be our first look. Really, they can call us, have us take a look at everything, and there may be, other defenses there.
Okay, great, thank you, Jay. Our next question, can a tenant raise the defense of failure to give a 30-day notice under the Federal CARES Act when the tenant does not have the rent to post into the registry of the court as required by Florida statute 83.60 subsection 2? So
that one's a little harder. It's very hard to get around that rent deposit statute, but in that case, I would probably file the motion to determine rent with an explanation that it's covered by CARES Act, and they should not have been able to file the eviction under federal law. And again, you can file a motion to dismiss for the same things. I'm not sure how the court is going to deal with that particular issue, but we do know that it is coming down the pipe, and we'll have to see how that works.
okay, one of the other questions, thank you. One of the other questions we have here is, Jay, if you could post or give your office's phone number and email contact. So you gave it earlier. Maybe if you could share that again.
Our main phone number is 407-841-8310. And when you hear our recording, you're going to press 0 to speak with the receptionist. If you're a tenant needing advice, tell the receptionist that you have a housing issue or you've been served with a complaint or a notice, and they will schedule one of our intake volunteers to call you back, and we'll do the intake that way. You can also email at info at legalaidocba.org. And I'll post those in the Q&A.
Great, thank you. Appreciate that. So I saw one of the other questions we had. Somebody was asking if the slides would be available from this presentation. What I can tell you is that we're recording this presentation, and it is going to be posted on the Orange County Clerk of Courts, our office's social media pages, and also our website. So you'll be able to go back and view this webinar at our website, myorangeclerk.com. Our next question, this is actually from a reporter, a housing reporter for Spectrum News 13. The question is for our own Roberta Walton with the Self-Help Center. The question is, has the Self-Help Center seen a noticeable uptick in the amount of tenants seeking help during the pandemic, and how do you expect that to change once this freeze ends, the moratorium ends?
Honestly, no. We have seen notably several landlords who are attempting to represent themselves come in asking questions about filing an eviction. But even just to go back and respond to that other question, the clerk's office has been working streamlined through from the courts to the sheriff's office. There's entities from the sheriff's office, if they receive, erroneously receive a summons that we issued throughout that moratorium, they would call and say, did we receive this in error? If the courts should see something that's coming forward for them to place on their docket, they've neglected to schedule it because they also saw that it was like, okay, this is for non-payment of rent, so we shouldn't move forward. So together, the three agencies have really worked well together to try not to let any slip through the hole. Of course, we have certified process servers that kind of negate and go around the sheriff's office, and that's by right, you can do that. But we haven't seen a lot of tenants because otherwise a tenant would need to respond to an eviction filing. And in this instance, we haven't really seen them. We can't hear you, Dane.
Oh, thank you. I forgot to hit the unmute button. All right. So our next, thank you for that. Our next question is simple one. How can you evict a person who's damaged my property? Not mine, but that's from the person asking the question.
I think if he wants to go back and look at the presentation or I put in the steps when you was talking about non-compliance. And so the first step would be that required notice. And if someone has damaged your property and you need to put them on notice by issuing a 7-day notice to cure. And so that's step one. And then the next step, if that tenant does not respond and come into compliance to cure whatever behavior or whatever the lease violation may be, then you have a right to come down and file.
Very good. Okay, next question. If a tenant has been asked to voluntarily vacate due to compliance issues within the apartment complex, however, has not paid rent as well, how will this play out? Does it depend on which matter the apartment complex files under? That's our next question.
Yes, yes, it does. Because again, there's a moratorium for non-payment of rent. And so if we receive a complaint for a non-payment of rent, then we're not going to issue a summons right now at the clerk's office. But if you are talking about a non-compliance issue because there are damages, then that's very different, and that requires, again, a 7-day notice. But, and I will tell you, we have seen quite a few landlords come in and try to negate that loophole of non-payment of rent by saying, hey, this person is ruining my property and they're not paying me anything. Any element of non-payment we're not going to move forward with issuing a summons until the moratorium lifts.
Okay, great. Next question. I am a property manager and have several wonderful tenants who are experiencing COVID job loss, work reduction issues, and are behind in rent. One severely behind. I would prefer not to evict if at all possible. Are there other financial or housing assistance options available to them? What help can I point my tenants in? What direction can I point them in, or agencies to contact that I can share with them? Who would like to answer that?
I'll comment on that one. If the landlord's willing to work with them, I would send the tenants to United Way, have them call 211, because they're going to have the most up-to-date information for every pot of money there is out there for assistance. So call them, explain what's going on, tell them your landlord's willing to work with you, and they may be able to provide some financial assistance or point you in the right direction. So hopefully the landlord and tenant can agree to something to keep them from being evicted.
Dane, if I can jump in also. This is Judge Dubois. I know the county got a large sum of money from the state, and the mayor's office assembled a group of key stakeholders from the community, members of the Judiciary, United Way, Clerk's office, Legal Aid Society, Orange County Bar Association to come up with a work group to look at some sort of diversion program or way to allocate those funds. I don't have specifics. We're trying to put something together and get something rolled out if we have to by August 1st. I am the court liaison to that group. Obviously, it's a monumentous effort for us to make that happen by August 1st. But I think what Mr. Mobley said was calling United Way. I know they are a major stakeholder in that organization, in that group. And they would be the best to direct you, but also I would be looking very carefully at things that the mayor's office is going to release probably in the next 5 to 7 days. That would provide some assistance to get people at least halfway there or partially there to open that conversation about working something out.
Great, thank you, Judge. I was going to mention that too, that that money had come down from the state to the different counties and that they were working on this evictions diversion program. So don't know if we have an exact contact once they're going to have, do you know who they could contact to get information as that rolls along?
It hasn't been formalized yet, and I don't want to bombard someone at the mayor's office that doesn't need to be bombarded. Because it would take away from their time to focus on the problem.
Exactly. So United Way, again, is still the best contact. 211 is the phone number for the latest information. They're going to know all the different pots of money that are out there for assistance.
And Dane, just really quickly, because I did sit in on those conversations, and I have been one of the work group representatives for the clerk's office regarding this. And so, again, what the group is trying to do is to come up with some recommendations on how to assist the community, because we live in the best community ever, and our leaders recognize that once that ban lifts, that we're going to have an issue. And so they're all working cohesively together. So the best case scenario is right now, wait for August 1st to get here, and should something transpire, I would say reach out. You can reach out to the Self-Help Center, you can reach out to the county, you can reach out to United Way, because we're all sitting at the table together trying to figure something out. So you would probably, legal aid, you'll probably be able to pick a piece of collateral up from anywhere.
Gotcha. Thank you, Roberta. Moving on to our next question. This is another one from Molly, who is a housing reporter with Spectrum News 13. This question is for Judge Dubois. How large do you anticipate the eviction caseload to be for those 5 county civil judges once the eviction freeze ends?
Thank you. Great question. So as I mentioned, we average about 800 to 1,000 eviction filings a month pre-COVID, just in a regular, great times. During the housing crisis, 2009, 2010, I believe that number was up around 12 to 1,400 a month. These times are much different than those times. I think this has hit a wider patch of our community. But fortunately, we have 19 judges here in Orange County, or 16 judges, sorry, in Orange County, county judges, and it's gonna be an all hands on deck. The criminal judges, obviously, we're not able to do jury trials right now, and we're very limited in some of our hearings and types of hearings that we can have. So they've all been told, and they all know, hey, when the ban is lifted and the pleadings come in, we expect you to be here and you're going to help process through some of these evictions. Frankly, the bigger concern I have are for our deputies who are going to be handed all these writs of possession that they're going to have to go execute. And that's why we're hoping that we can get things moving with the diversion program and get things worked out where we're not kicking people out of their houses, but we're also coming up with solutions. But I know since March 18th or so, when we really shut down, quote unquote, we have 400 pending evictions. That's it. That's all that's in the pipeline. Deputy Garcia talked about the ones that were pending with when the moratorium went in place. Folks, if you're out there and you're listening to this and you haven't paid your rent to your landlord, put it in the registry. That money will not get dispersed from the registry until a hearing is held. I can guarantee you that's the best way to file a motion and say, hold on a second, I was supposed to be evicted. Here's all my money. Can we talk? And you might get that money back, or you might be able to stay in your home. But I can guarantee you, if there's no money in the registry and that eviction was pending, more than likely you're going to be out. So I hate to be black and white like that, but that's how, as judges, we have to rule is black and white, and that's what the law says. So.
Great, thank you, Judge. So again, we've had a question about accessing this webinar later. Want to repeat for those who may have just joined that definitely this webinar is being recorded. It will be posted on our social media pages. Simplest way, our website, myorangeclerk.com. Next question we have is kind of a long one. I'm going to try to go right on through it as quickly as possible, but this is, what if the landlord fails to repair things that should be repaired promptly? Things like coming up from the toilets problems from outside, air conditioning goes out, someone in the house is elderly, the landlord gives 7 days notice, but cannot wait to get someone to do repairs, then does not have money to pay the next month's rent. In this situation, repairs using UPT rent money. If the landlord files a complaint, is there an exception for the tenant not having to put the next month's rent into the court? Who wants to take a stab at that?
I think I'll take a stab at it. So I think what they're saying is if the landlord doesn't fix the property, can they do the rent withholding through the 7-day notice and then pay for the repairs in the meantime because they're of an emergent nature? In that case, if the landlord agrees and allows you to withhold it from the next month's rent, fine. But what normally happens in these situations is even if you do the rent withholding properly, you serve that 7-day letter on your landlord asking for the repairs to be done, and they don't do it, and they do have 7 days to make any repairs, even, you know, if it's a water break or something like that, that there's shorter time frames, but most repairs, they get that 7 days. If they don't do it and you pay for it out of pocket, if the landlord files an eviction because you're not able to pay your next month's rent, barring any of the moratorium issues, what normally happens is a proper rent withholding would be a total defense against an eviction. Now, that normally is that you're withholding the rent, haven't spent it, and can put it into the court registry. If it is an emergency nature, what I would say is in responding to the eviction, you're going to want to file a motion to determine rent. You're going to put the receipts from whatever contractor you had to make those repairs into the registry along with any of the remaining rent that is due and ask the judge to decide.
And Dane, if I could just add to that, when I was in county civil, it's very important to put receipts in, not quotes. There's a big difference between a quote to get the water replaced or water fixed and a receipt showing you actually paid it. So just make sure of that. And as crazy as it sounds in the state of Florida, there is no right to air conditioning. There's a right to heat, but just because your air conditioner breaks to keep you cool in summer, it's not a reason to withhold your rent.
Wow, okay. All right, Judge, this next one's for you as well. Can you tell us more about how these virtual eviction hearings would work? For example, how would this work for tenants who don't have a computer or internet at home?
Sure, thanks. Great question. So what we've done in the Ninth Circuit in Orange County is we've set up what we've called kiosks or remote satellite courtrooms. So we can kind of get around the in-person hearings by having an individual who doesn't have the means at home, internet or computer, to come down to the courthouse and go into one of our conference rooms in the mediation office or up in room 365. And we'll be setting up more of these once the eviction moratorium is lifted for people to come down to the courthouse, and we would do it exactly how we're doing. The judge would be in their courtroom. We would have Microsoft Teams set up. You would be logged in on one screen, the landlord would be on another screen, and we would have the hearing. The Supreme Court has allowed us to do oaths of, to put everyone under oath remotely via video conference like this again. So we would have the means for you to come down to the courthouse and do that. You would be noticed with a date and time to show up for your hearing. If you're not there, we can't help you with that. But if you're there, we will have the technology available for you to participate in your hearing.
Okay, great. Thank you, Judge. Our next question, again from Spectrum News 13. Questions for any and everyone. Do you have a sense of whether the state judicial system is going to, on a wide scale, take the pandemic into account when hearing eviction cases and making decisions after the freeze.
So I'll start at that. Unfortunately, we are 1/3 of government. The laws in the state are made by the legislature, and they write the laws. The governor signs them. We have to follow the laws as they're written. So unless there's some emergency language or a change in the statute that allows us to take into consideration a lack of rent or a lack of payment or the COVID situation or someone's unemployment, we've got to look at the letter of the law in the black and white. And the black and white says, if you don't pay rent and it's not in the registry, unfortunately, there's nothing we can do. I can tell you from personal experience that landlords in this community have been amazing in the past, and they've been willing to work. And they would say, Judge, look, they put half the money in the registry. They put 2/3 of the money in the registry. We're close. We want a chance to work something out. Reach out to your landlord. Don't be scared. Talk to them. They want to work something out. They're afraid of the empty apartments and homes as much as everyone is. But we can't, I don't see the courts usurping the legislative authority and coming up with their own laws. That's just my belief.
Okay, thank you, Judge. Next question, how can tenants proceed with renting in the future following an eviction? If an eviction due to COVID-19 occurs, is there a possibility of this being left off of a tenant eviction history?
I'll answer that one, and the answer's short and not so sweet. No. An eviction action filed in the court is a public record in Florida. We have broad public record laws. There's no sealing or expunging an eviction, so it is going to follow you around. There was some talk at one time about the next round of CARES assistance from the federal level, having something as far as COVID markers on people's credit bureau or their credit line entries that say this debt is related to a pandemic issue for COVID. We don't know if that's going to come or not. That may affect how future landlords look at your credit pull or your rental history. But as of right now, no, there's nothing.
Dane, really quickly, I also like to say it truly is a timeliness issue, because we have a lot of people who come into the self-help center who say, well, we worked everything out. We settled and I paid them. But the eviction complaint has already been filed. And so they come in saying, I still can't find anywhere to rent because they see that an eviction was filed against me. There's nothing the clerk's office can do. The clerk's office cannot remove that just because there's been a settlement agreement on the case and there was a voluntary dismissal. Once it's filed, it is there.
And I can say that very often we would get petitions to seal or expunge an eviction, kind of like a criminal arrest. There's no statutory animal that allows us to do that. So we can't seal or expunge it. Once it's there, which is why, again, I think what we were all telling everyone is talk to your landlord pre-filing. Talk to your landlord. If you've paid your rent. Talk to him before and get it worked out.
Okay. Our next question, asking about the affidavit from the landlord. Is there a form for that? I don't know what we're speaking about here. Affidavit from the landlord. Is there a form for that?
I think she's talking to you, Judge.
Yeah, my guess is that's the issue that I brought up with the if the mortgage is federally backed and whether the CARES Act would prohibit someone. There's not a per se form. My guess is that Ms. Walton has a standard affidavit that you can handwrite in and get notarized and signed that basically says, I hereby swear that this is not a federally backed or federally insured mortgage. That's about all you got to say. But I'm sure Ms. Walton, I'm sure you have one at the self-help center, right?
And again, because we all work so well together here in terms of these panelists, I made a mental note, Judge, to come down to see how we might be able to help pro se litigants post the ban when it comes to that affidavit.
Just to clarify, Judge, you said that was going to be a requirement for the entry of the final judgment?
My concern is that if that ban is still in place until October and the state lifts the moratorium, we're going to have competing interests of, well, it's a fairly insured mortgage. And, then if we have, well, a defense of it's a federally insured mortgage, but there's no money in the registry, what do we do?
That's a great question. I'd love to have the answer to it.
I'm glad I'm in criminal now.
Okay. All right, we have just a handful of questions left, about 4 more. So next question we have is, what is the consequence for the landlord in the case if his mortgage is under a forbearance? I mentioned this because of the time the process is done, the forbearance may end.
I'll take that one. The landlord's mortgage in normal times has nothing to do with your responsibility to pay your rent, because you have a separate contract with him saying you're going to pay the rent. If you're talking about a forbearance because their property is a CARES Act covered property, then you have rights under the CARES Act. But if you're talking about just their lender, who is not CARES Act related, offered them a forbearance on their mortgage, unfortunately, it's not going to help you as a tenant, because you're contractually bound by your lease to make your payments on time.
Okay. Thank you. Our next question is, how long do I have to wait to recover rent by court when tenant is not paying? Don't know that it's not a very clear question, but how long do I have to wait? Sounds like maybe they're wanting to know how long they're going to have to wait before the tenant would be forced to pay, but it is really all through this process we've been talking.
Yeah, I think that depends on what type of notice you've served, when you file the eviction, and if you seek count 2 for damages. The time frames, vary depending on what you're asking the court. So.
And if you file a count 2 for damages and you get those damages in the past due rent, that judgment, you may not recover your rent for 20 years. That judgment is good for 20 years.
Or more if they renew it. So
right. You may never get your money, which
Yep.
is why some people will give up the pursuit of count 2 just to move forward and get the people out.
right.
So,
On that note, though, even if the landlord doesn't seek count 2, I think it's important for everybody to remember that this was a contract. You agreed to make those payments. You defaulted on it. It's still a valid debt, and landlords can turn that over to a collection agency. They can report it to your credit bureau. So it can follow you around even if they don't take you to court for the count 2 of damages.
yeah. And I've seen people put liens on people's vehicles, and when they sell the vehicle, the landlord will get paid off, or boats or something that someone owns. So
I think it's important. This is important to talk to your landlord. If you can make a deal, say, hey, don't file the eviction. Maybe I can move out. Maybe I can do something. If you'll forgive my rent, I'll move, get it in writing and get it forgiven, or, come to some arrangement if you can.
Well, and if a landlord's willing to do that, Ms. Walton went over the cost. You're saving them roughly $500 to $600. That
Right.
they're throwing good money at bad, that they're going to know, look, I'm probably never going to recover this anyway. Let me just cut my losses and let people move on.
Yep.
And you don't have an eviction on your record.
Okay. Next question. We have a couple more left. Next, we're down to 3. So if you have a last minute question, get it into the Q&A section soon. All right. In serving eviction notices, can the Orange County Sheriff's Department ensure that resources are included in these packages, such as information on Mayor Deming's work group results, services such as 211, Legal Aid Society contacts, etc.? So I guess this is one for our sheriff's deputies.
Sure. I'd like to go ahead and answer that question. I do appreciate the question, but the questioner should take in mind is that the sheriff's office is the last stage. We are the end stage of the whole process, the eviction process. Each agency has resources and different means to help tenants that are struggling, which is why forums of this nature are so important, to advertise what is available through the county. By the time the summons is being served, the complaint and the summons is being served, by the time the 24-hour notice is being posted by a deputy, we're well beyond that. It should be taking heed of what Judge Dubois' advice is to be concerned with maybe placing money into the court registry and then having a day in court, because obviously the rent has already gone unpaid, if that does answer the question.
Thank you, Sergeant. Yes. And of course, you can always get this information through United Way, through the county website, 211, those resources are there. So our next question, if an eviction is filed but the court decides in favor of the tenant, does the tenant still have an eviction action showing up on a check of their tenant history? We've kind of discussed that.
Yes.
I guess kind of the follow-up question I had to that is, how much does that affect you though as a tenant when you're trying to then find new housing? Is that something that is always checked?
It's checked, but if from my perspective, if I was the tenant and I prevailed against a prior landlord who filed a wrongful eviction, I would pay the clerk's office $3 for my certified copy of my final judgment in my favor and attach that to every application that I filed looking for a new place of residence.
And if I might, we have a large number of people who do that. They come down and they ask for a certified copy of that judgment, and we don't have a problem certifying the stipulated agreement and the voluntary dismissal. In some instances, when they resolve the matter themselves. However, I will say and go on record that a lot of landlords still don't care. If they see an eviction at all, they consider that person's hands off.
Yeah, I'm not sure how we're going to handle that post this eviction tsunami. You know, I got to think some of the larger complexes have to loosen up a little bit because, you know, a large portion of people are going to have an eviction, you know, no matter what happens in the final judgment, they're going to have that eviction. But yeah, I've seen, you know, a workaround. They pay a higher deposit. They pay some, you know, a higher fee of some kind. So there's all different ways, but I've had a lot of people that just simply cannot find housing because of that eviction. And what they do is it's like pulling a credit report. There are special reporting agencies that go out and search the court records. The landlords use those. And if an eviction pops, a lot of these larger complexes, their system is set up to just generate a denial. It's not even like someone's going to look at it to see what happens. There's an eviction on the record, and they're just dismissed out of hand as an applicant.
Okay. Next question I have here is one that we received before the webinar. It's kind of a long one. I'll try to paraphrase. We have a tenant, so this is from a landlord. We have a tenant who has not paid rent for months. We made repeated attempts to assist in their situation without any effort from them to pay. They said they applied for other financial assistance. Their lease is up at the end of the month. They did not request to renew and have indicated they'll be moving out. If they move out without paying back rent or outstanding bill for water, sewer, trash, that we also know they've not paid, what is our legal recourse, as it will no longer be an eviction? Also, if they give no forwarding address, how would you be able to find them to pursue the claim?
Now we're talking a small claim suit. And so, you know, as with anything, the small claims actions effective January 1 went up from 5,000 to 8,000. And so you can sue for monetary matters up to $8,000 in small claims court. Again, as I said earlier, in the self-help center, if you intend to represent yourself, we also do provide support for small claims actions at the Clerk's self-help center in room 340. But that would be your course of action.
Great. Thank you, Roberta. We're down to our last two questions. All right. Once the moratorium is lifted, does the sheriff's office or courts have any autonomy to enact their own bans on evictions? For example, can the Orange County Sheriff decide his deputies will not serve final writs until a further or future determined date? Until a future determined date.
As far as autonomy, we are, the only autonomy we have is based on our manpower. It's first come, first serve. I have 10 deputies to execute all the evictions within the county. That's our only discretion. We have to follow the court orders. We are giving them, again, every court order is given the exact same treatment, given the exact same precedence. So as far as our ability to make a decision on whether or not we wish to go forth on a court order, no, we do not, by statute.
And Dane, the courts don't have the
Say that again, Judge.
the courts don't have the autonomy to go around a Florida statute or a governor's order or the Chief Justice of the Florida Supreme Court's order. Once the moratorium is lifted, the laws in the state of Florida are in effect, and we've got to comply and follow those laws.
Thank you. Exactly. All right, and our final question we have for the webinar tonight. As a landlord, I have filed in March for an unlawful possession, but the eviction ban has stopped me from evicting squatters. What can I do?
That should not be the case. If we're talking about an unlawful detainer action, you can feel free to come down to room 350 or 340 and file that action tomorrow. So I'm not certain, but when you talk about squatters, that might be a little bit different because sometimes you could be talking about an ejectment case. But from my perspective, the waiver and the ban is only on unpaid rent actions, not unlawful detainer actions.
Yeah, and an unlawful detainer by its nature is when you're trying to remove someone from the property who was never paying rent and was just an invitee or a guest that now you're like, all right, it's time's up, you got to go. If you've already filed the case, my suggestion, I provided the email addresses, email the JA with the case number and say, hey, can we set up a virtual hearing on this case and see if we can get a hearing set up? Obviously, there's no money that's going to be put in the registry because no money's owed. And we can't do a default judgment on an unlawful detainer. Once we know someone's been served, we have to have a hearing. So email the JA, ask for a hearing, and they'll try and set one up virtually via Teams or Zoom.
Gotcha. And Roberta, you said come down to 340, 350. Do they have to physically come to the courthouse to do that?
No, and I was actually getting ready to hit my button. Thank you, Dane. Because we really are encouraging people to stay home and stay safe. And so that is, I don't know if a lot of people recognize or not, but we do have the Florida online portal for people to file their claims via the e-portal. It's a really simple process. We have some plain language instructions. I know the Ninth Judicial Circuit has instructions on their website. We have instructions on our website at www.myorangeclerk.com. Or you can call us and we will give you some directions on how to file your case online. At this hour, there's really no reason why you have to leave home. You can do it with the press of your computer.
Okay, great, thank you. So that brings our webinar to a close unless anybody else has something else they'd like to share.
I did want to say, maybe people might ask, well, where would I get the forms? On the clerk's website, we also offer each of these packets for sale. We have small claims packets, we have eviction packets, and we have unlawful detainer packets for sale that you can pay the fee, download the forms, complete them, and then go to the Florida electronic portal and file them.
Great. Okay, if there's nothing else anybody else would like to share, we're going to wrap up and close. Just want to say the Orange County Clerk of Courts and Clerk Tiffany Moore Russell understand the importance of these conversations in the community. I want to thank our panelists for joining us, taking time to talk about this very important topic. We hope this topic discussed in this webinar the entire topic was very helpful to you. And a big thank you to everyone for joining us to help navigate during this time. Once posted, you're going to be able to view this video at any time, again, on our social media platforms, meaning the Orange County Clerk of Court social media platforms, also on our website, myorangeclerk.com. As always, make sure to follow us. We're on Facebook, Instagram, Twitter, LinkedIn, and to get all the updates. The Ninth Judicial Circuit also is on social media for court administration and their website. So also join and check out their websites for information. Thank you for joining us. As we mentioned at the beginning of this webinar, we'll have a short survey that's going to appear on your screen once we close out of this. So please take the time, fill out the survey for us. That helps give us information, gives us feedback on how we did here, providing you information and even topics in the future you'd like to see. So on behalf of Orange County Clerk Tiffany Moore Russell, thank you for joining us. Have a good night.